may thank you very much for your patience. As may have been relayed to you, my laptop went missing from the X-ray machine, but has now been recovered. So,
very glad to hear that you got it back.
Well, so am I, my lady. Yes, it was going to be challenging to to run the afternoon submissions without access to my electronic notes.
Somebody else picked it up by mistake when it
so
went
I'm told
through.
me.
Yeah.
Yes.
A challenge which you would have risen, which would have made it more interesting for you. Anyway, now you've got your laptop back.
Yes.
What are you going to say, either from it or from your...
Well, also, I was going to start with construction, the pure construction points, unencumbered by the statutory and regulatory points at this stage. Although I would say that's a generous approach to Mr. Williams to take, because of course a contract like this falls to be construed before one gets to questions of enforceability in the context of a regime in which not all types of contingency agreements are enforceable. But I'm prepared for these purposes just to look at it as a contractual interpretation exercise.
Well, is that relevant to the exercise of pure interpretation? I mean, I appreciate you say it's highly relevant to later questions, but when it comes to interpreting the agreement, how relevant is that?
It's relevant, my lord, in as much that this isn't a familiar type of agreement. People aren't routinely entering into defendant DBAs in relation to the defence of incoming claims. Parties routinely are entering into DBAs in relation to pursuing claims in employment tribunals, slippers and trippers claims in personal injuries context. There are solicitors out there who will transact on DBA terms. That's a familiar context in which one enters into agreements with an element of contingency. The construction being put by Mr. Williams on this agreement is by no means a familiar type of agreement. In fact, it appears to us to be entirely unprecedented. No one previously has suggested it is possible to enter into this type of agreement. And so if such a novel type of funding arrangement was to be adopted, we would submit it, or necessary to do so, that you would expect to see rather clearer words.
It's a pure matter of contract law. If you were starting from a clean sheet, in theory, parties could agree to do that.
Yes, my lord.
And would then be a question of looking at the words they used,
yes,
to see what the effect of those words were.
My lord, that's exactly right. If one was starting from a clean sheet against a background of freedom of contract generally, here, when one is in a regulated environment,
I suppose there may be a presumption of legality which applies as a matter of construction, so that if two readings are possible, then you might construe the agreement so that the parties have made something which is legal rather than illegal.
Yes, my lord. Yes. I wouldn't.
So to that extent, there may be
to that extent, but the narrower point I make is simply that a novel and unfamiliar type of funding arrangement, if that was what was sought to be achieved, one might expect the parties to have used rather clearer words to define that as being their intention. But the relevant point of construction in any event is whether Candey's right to payment was triggered by the retention of some of the shares their client had started out with. The point of construction is not whether the shares claim fell within the framework of the DBA, because it plainly did. And what that meant was that Candey had no entitlement to payment in respect of any work done on the shares claim, save insofar as the shares claim itself generated a recovery for Mr. Wojakovski, potentially through a costs order, for instance, or Mr. Wojakovski generated a qualifying recovery in one of the other claims, or, and perhaps this is the more realistic expectation of the parties, through a global settlement in which there was a return to Mr. Wojakovski without the need to distinguish which of the 15 claims which were within the DBA had generated that particular recovery. So the point of construction, as I say, is simply whether the right to payment was triggered by the retention of some of his pre-existing property. And the legal principles of construction, unsurprisingly, aren't in dispute. They're conveniently summarised in a very recent case of this court, Soteria Insurance. It's in the Bundles Authority 2, tab 39. We don't need to look at it because the principles are obviously entirely familiar, that one construes the words used in their documentary, factual and commercial context. And we see that from the trio of Supreme Court cases dealing with these principles of construction. So in relation to the words used, the agreement obviously we've been looking at is at page 14 of the supplementary bundle. Tab 2, paper version. And so one starts fairly obviously with the title, a damages-based agreement. And we say that suggests an arrangement for the sharing of damages or financially equivalent recovery, and a point obviously made by the judge at paragraph 24, and which featured prominently in this morning's exchanges. And then moving on to paragraph 2, the trigger for payment was then defined in the body of paragraph 2. But one word that hadn't hitherto been focused upon is the word proceeds, a defined term in bold in brackets in the fourth line. And as a matter of ordinary English, we submit that the word proceeds identifies what has been generated by the litigation in precisely the same way as the proceeds of sale identifies what has been generated by a sale. And the proceeds of sale or the proceeds of litigation are not apt terms to describe property which was owned throughout by, as the case may be, a vendor or a litigant. And that basic idea is then reinforced by the use of the word recover in paragraph 2. And Mr. Williams is right to point out that the word recover, the verb recover, is used in relation to the monetary benefits as distinct from the verb derive being used in relation to the benefits which aren't in cash terms. If paragraph 2 had stood alone, then my submission would be that the expression to derive a benefit in its context has to be construed consistently with the words preceding them. And so the derivation of a benefit through the debt being written off, through being paid in gold coins, that would have been a qualifying type of benefit. There's nothing in that language, we say, to suggest that this envisaged the defence of an incoming claim being a qualifying benefit. But it's artificial and unnecessary to construe paragraph 2 of the DBA in isolation, because it obviously doesn't stand alone. It has to be construed alongside the other clauses in the agreement. The two of particular relevance, which have already been focused upon both this morning and obviously by the judge, paragraphs 34 to 35, are paragraph 5. If we are unable to recover any monies, you will not be liable to pay us anything. And paragraph 8, and the language in particular, from your opponents. And the judge, we say, was entirely right to identify that even if paragraph 5 is construed sufficiently generously to contemplate the non-monetary benefits for which paragraph 2 provides, nevertheless it is reinforcing what is apparent anyway from the thrust of the agreement, that this is focusing upon a recovery. And if there were doubt about that, then it's resolved in any event by paragraph 8, which makes entirely clear that it's talking about recoveries from an opponent. And so that, in very short terms, is the textual analysis, construing the words used in this particular agreement within their documentary context, without regard at this stage to the type of claims which were on foot and the commercial expectations. The DBA, on its face, contemplates a transfer of value to Mr Wojakovski from one or more of his opponents in the litigation. He is getting something into his hands which he didn't previously have. Exactly as my lady, Lord Justice Andrews, observed, it's all about winnings. If I go to the casino and I lose on every single spin of the roulette wheel, then there are no winnings. And the fact that I went to the casino with £100 and I left after losing only £75 doesn't mean, in any sense, that I have won or obtained a benefit to the tune of £25. And if I'd agreed to share a proportion of my casino winnings with Mr Williams, then it would be absurd for him to suggest that he could come after a proportion of my £25, saying that I had preserved those, not lost them at the casino, and thereby obtained a benefit from my trip to the casino.
Well, you may have derived the benefit of learning the futility of gambling.
My lord, yes, indeed, but that certainly wouldn't be an immediate financial benefit of the sort contemplated. No doubt beneficial for other reasons, my lord, yes. But that's how absurd that we say this is. It's entirely obvious from the clear terms of this DBA what it has in mind, and indeed it's made clear in the opening words of paragraph 2. As you do not wish to pay our hourly rate charges, nor indeed did Mr Wojakovski wish to continue paying Mr Rea's charges, even if he had the funds to do so, we agree to share risk in accordance with the DBA, and that's sharing a risk in respect of recoveries in relation to sums which Mr Wojakovski didn't start out with, but which he has recovered from his opponents as a result of the litigation. And so that's the textual analysis. A key part of the wider factual context is that the shares claim involved a claim for the return by Mr Wojakovski to his parents-in-law of the 50% shareholding in TGL which they had transferred to him. And their case in the shares claim is that they had transferred those shares to him, unaware that he was stealing money from the companies. And they say that, well, they said in the shares claim that they never would have transferred those shares if they'd known that he was defrauding the companies and indirectly them as the shareholders. And as at the date of the execution of the DBA, there were two major uncertainties in relation to the valuation of TGL. These are both identified by the judge. Mr Wojakovski had yet to admit how much he had actually taken from the Tonstate Group companies. The admission to which Mr Williams refers in his skeleton at paragraph 9 came only later. And the other major uncertainty was the tax consequences of the years of these unlawful payments, which had yet to crystallise. And these were obviously picked up by the judge in the DBA judgment, and no suggestion that the judge had erred in identifying these as being relevant elements of the factual matrix. And the relevance of those facts to the question of construction, as was pointed out in exchanges this morning, is that there is no machinery, obviously, in the DBA to cater for how that uncertainty over value and tax liabilities was to be resolved. And that deficiency in our submission is particularly striking when there is an express netting provision in paragraph 2 of the DBA, whereby tax liabilities would need to be offset against the sum to which Candey would otherwise be entitled. And the judge was right to say, and it's obvious in any event, that a netting of that kind requires a cash value to be put upon the shares. But there is nothing stipulated as to how those shares would be valued in order to derive a cash value, nor even when the netting off should be treated as effective, in circumstances where, as the judge pointed out, the tax position might yet take years to crystallise. So that there's not even the most basic machinery as to the date as at the net position should be arrived at. And this is not a point as to whether the DBA is too uncertain to be enforced, which is the straw man Mr Williams sought to attack at paragraph 37 of his skeleton, but whether objectively analysed, the parties should be taken to have envisaged that retention of illiquid shares of uncertain value would trigger a right to payment. And the judge, we say, was right to conclude that the absence of any such valuation machinery was a strong indication that the parties had not contemplated that retention of shares in TGL would trigger a right to payment under the DBA. And my Lord Justice Mayles made the entirely fair observation that there was already a degree of uncertainty inherent in the DBA about possible valuation issues, by virtue of the fact that it contemplated the possibility, at least, of a non-cash benefit which would need to be valued. But that was an unknown, which couldn't sensibly be legislated for. The theoretical possibility of Mr Matthias or the company seeking to settle with Mr Wojakovski in exchange for a property or a bag of jewels or some such thing.
Or indeed some of his shares.
Exactly. Well, yes. The possibility of settlement on terms which had yet to be foreseen, which weren't in the contemplation of the parties, it's readily explicable that they wouldn't have sought to cater in a DBA for how different types of asset classes, could have been a car, how that should be valued, because those were unknown unknowns which were outside the contemplation. By contrast, The shares, which Mr. and Mrs. Matyas were seeking to have retransferred to them, were squarely in issue and one of the three principal claims which this DBA sought to cater for. And so to have failed to make any provision for the valuation of those shares, which was a known unknown, we say is a strong pointer, as Mr. Justice Zacaroli identified, to this simply being outside the contemplation of the parties. And if, as Candey now contend, retention of the shares triggered a right to payment in one of the three claims, then the absence of that machinery was remarkable as at the date of the original agreement in September 2019, but it is quite extraordinary when one considers the chronology in May 2020, when the DBA was being amended and the shares claim settled, because that amendment of the DBA occurred almost simultaneously with settlement of the shares claim. And there are actually two amendments to the DBA in quick succession. The percentage was first increased on 12th of May, and then the other terms were revised on the 20th of May, including, as Mr. Williams pointed out, to delete paragraph 3. We don't need to look it up, but that was a supplemental bundle, pages 20 to 23. One sees the email exchanges. And all of that amendment exercise, in terms of timing and settlement, occurred in tandem with the settlement of the shares claim, in relation to which an offer of settlement was made on our side on the 13th of May. Then there was this discussion then of the more detailed terms. A consent order was signed on the 20th of May, and then it was sealed on the 21st of May. And that supplemental bundle, pages 88 to 89. And so it was happening at the same time. The second amendment to the DBA took place when there was already an offer and an agreement in principle had been reached for the settlement of the shares claim. And so objectively, the absence in those emails of any mention of Candey having acquired a right to payment by virtue of the terms upon which the shares claim was settled, let alone how that right to payment would be quantified, having regard to the uncertainty of the shares' value, we say is explicable only on the basis that it simply wasn't part of their deal with Mr. Wojakovski that retention of the shares would trigger a right to payment. And even if it were the case that Candey subjectively believed that to be the case, of which there's no evidence, it plainly wouldn't bind Mr. Wojakovski unless this court could conclude that objectively there was a reason to think that that indeed was the deal that he'd struck with his solicitors. And indeed the first mention of Candey having any right to payment arising out of the terms of settlement of the shares claim was in the notice to the official receiver on the 5th of November 2020, only after Mr. Wojakovski had been made bankrupt. And so that factual context, having regard to the nature of the shares claim and the difficulties of valuation of the shares themselves, all we say supports our position rather than Candey's, but is also relevant and helpful to look also at the overall commerciality. As to that, Mr. Williams says it's uncommercial and therefore unlikely to have been agreed that there should be an arrangement whereby Candey get no victory payout, even if they were entirely successful in defending the shares claim. And, Lord my Lady, as to that we have 2 points. At first, and as a generic point, it's perfectly open, clearly, for solicitors to agree to work on one element of a panoply of claims in the hope of receiving their payment from one or more of the related elements. On any view, this was an umbrella agreement which embraced a host of interrelated claims, and there's nothing at all surprising or uncommercial about solicitors working on all of them together, recognising that it was only some of them which could trigger an entitlement to payment. But the second and more fact-specific reason is that Mr. Williams' submission about the perceived uncommerciality of an entitlement to the shares claim when one looks at the shares claim in isolation, overlooks the fact that there was a common factual dispute which permeated all three of those main claims, all three of those principal claims, the main claim, the petition, and the shares claim. And the common factual dispute was that Mr. and Mr. Matthias were accusing Mr. Wojakovski of having for years been stealing money from the companies behind their backs. And that was the basis upon which the main claim was being pursued. This money had been taken without authorization. In response to that, Mr. Wojakovski in the petition, first of all in defense to the main claim, and then separately in his petition, was saying, well, this is desperately unfair to accuse me of this because you, Mr. Matthias, knew what I was doing. Mr. Matthias denied that, and so that was the common issue in both, the common key factual issue in both the main claim and the petition, also in the shares claim, because the premise of the claim for it to rescind the transfer was that Mr. and Mrs. Matthias wouldn't have dreamt of sharing with their son-in-law 50% shareholding of the family-owned company if they'd known that he was stealing money from those companies in his capacity as CEO, but not yet a shareholder. And so, viewed in that light, when there's a common factual dispute, which in practice provides the answer to all three of those related claims, there's nothing remotely surprising or uncommercial that Candey should have been willing to enter into an agreement on these terms, which effectively required them to vindicate Mr. Wojakovski of the factual allegations which were made against him that he was effectively a crook. And the further point on commerciality is that Candey's invoice for £2 million plus VAT for having preserved 25% of Mr. Wojakovski's original shareholding necessarily presupposes that they would have claimed 9.6 million if they had been wholly successful in defending the shares claim. And that's 9.6 million pounds, nearly 10 million pounds, which Mr. Wojakovski would have needed to find from his own pre-existing resources. Because ex hypothesi, this is not based upon new money which has come into his hands or new property which he didn't previously own. This is him having to fund his lawyers to the tune of £10 million from the resources he had in the first place, in circumstances where he didn't regard those resources as being sufficient to be able to continue to pay Mishcon de Rea on a normal hourly rate basis. And so if Mr. Williams wishes to emphasise commerciality, that is a staggeringly uncommercial deal, an unattractive deal for a party in Mr. Wojakovski's position. It's entirely obvious from the commercial context that he went to Candey because he felt he couldn't afford to continue to spend money from the resources he had control over, and so therefore wished to fund his lawyers' legal costs from the proceeds of litigation, necessarily from new money. And so we say that the meaning of the DBA is entirely clear. Mr. Wojakovski needed, in order to generate a payment entitlement on the behalf of his lawyers, to have obtained something from one of his opponents, one or more of his opponents, as distinct from having preserved some of what he already had. To which Mr. Williams says, at paragraphs 29 to 32, that there was a recovery, and he did get something that he didn't previously have, because he obtained the protection against dilution of his shares. And as to that, the first point is that these are simply not the benefits on which Candey have calculated their 29% and issued a £2 million invoice. Candey regard themselves as entitled to 29% of the value of the shares themselves. And hence there was no mention in Candey's application notice, that's at core bundle, page 115, and no mention in Mr. Nabarro's witness statement, relevant bits dealing with it being supplemental tab 1, page 12, paragraphs 46 to 47, there was no mention of these ancillary benefits when the application was made. And if the ancillary rights were the qualifying benefits said to have given rise to the entitlement, then necessarily Candey would only be entitled to a percentage of the benefit attributable to those, the value attributed to those ancillary benefits. But my lords, my lady, they could never sensibly be valued separately because of a second point, which is that the ancillary provisions of the consent order are not properly characterised as benefits at all, but merely the avoidance of further detriment.
Well, you say that he started out with 50% of the shares plus the right to block dilution, and he ended up with 12.5% plus the right to block dilution.
Exactly that.
Yeah, well, I think that's the point you make in your skeleton.
Yes. And so as to Candey's other criticisms of the judge, we say that he was right to reject all the arguments that were made before him, which have been repeated on this appeal, essentially for the reasons he gave. The criticism by Mr Williams of the judge's characterisation of the substance of the wider dispute and Mr Wojakovski's inability to fund a buyout of Mr and Mr Matyas's shareholding is particularly unfair in circumstances where Mr Justice Zacaroli had been fully docketed to the 3 sets of proceedings since March 2019. He'd heard multiple heavy applications, some of which did involve the investigation of Mr Wojakovski's asset and funding position, in relation to which there was ample evidence, and the judge was uniquely well placed to make the observations he did about what the substance of the dispute was really about. And with the benefit of that insight into the wider factual and commercial context, when he came to the agreement and construed it as the authorities told him he must, in accordance with their context in the document and their factual and commercial reality, then we say he was obviously right in relation to his interpretation of the agreement. And my lords, my lady, I didn't really have anything more to add on that part of the case, on the pure.
Well, you haven't really said anything about Clause 9, which Mr Williams placed considerable emphasis on.
Well, we embrace what Mr Justice Zacaroli said in relation to that. He didn't think it was a strong pointer either way. And we say it's equivocal. The fact that it was an umbrella agreement, insofar as we derive support from paragraph 9, simply goes to explain why.
Well, but of course that's part of the issue, isn't it? Because Mr Williams' submission was that it wasn't an umbrella agreement. It was, in effect, 15 different agreements.
Well, as to that, my lord, we would embrace Lady Justice Andrews' observation that it doesn't say it consists of; it says it's equivalent to. And my lord, your lordship's point to Mr Williams was that it's about retainers. It's not about payment entitlement. It's just the high-level contractual framework. So the settlement or the termination of one claim wouldn't terminate others. The DBA in relation to certain claims could subsist, notwithstanding it had fallen away elsewhere. It serves that purpose perfectly well. But in terms of the wider factual context, we say that it does have that umbrella nature, because the parties entirely sensibly chose to regulate their affairs in relation to these different claims by reference to a single agreement. And there's just simply no particular reason in this sort of context why the court should have any inclination to find a strained interpretation of the wording, which is generous to a firm of solicitors, in circumstances where they can be expected to look after themselves and clearly provide for the agreement to which that they want.
That sounds like a submission contra proferentum, which is not a favoured canon of construction these days.
Well, it's certainly not my first point.
Fair enough.
But looking at the overall justice of this, it is recognised to be an appallingly drafted agreement. It's not clear. It's possible, as my Lord Justice Mayles observed, that some of the paragraphs may have been jumbled up. It's certainly not clear how the machinery of netting off would work. The judge was prepared to construe that, as Mr Williams submitted, because it was unnecessary for him to decide precisely how the payment mechanism would work in terms of the netting off of tax liabilities. But there's simply not any imperative to come to Candey's aid through some purposive construction which gives rise to this, because in fact everything, not only the language but the commercial considerations, point firmly in the other direction.
You make the point that the amendments to the DBA, increasing the 4% and deleting clause 3, were at or about the same time as the settlement was being negotiated.
Yes.
By which time it must have been apparent that there wasn't going to be a net recovery.
Yes.
So what did the parties think they were doing when they increased the percentage from 25 to 29? Somebody must have thought that's going to get us more money, or that's going to mean I have to pay more money. But what was that? What was that extra 4% of?
My lord, I don't know. There's been no disclosure. Plainly, there must have been a negotiation that led up to the amendment of the percentage.
I mean, that's as I understand it, that is inexplicable on your case, but Mr. Williams would say it's explicable on his because it's
what we said was inexplicable that there was no mention of how.
No, that was on a valuation point. Yes. That's a separate point. But the fact that they thought it was worthwhile amending the percentage suggests that they must have thought that money might somehow become payable at a time when, as you've just accepted, there wasn't going to be a net recovery in favour of Mr. Wojakovski.
Well, my lord, Candey's position, as articulated on this appeal, is that one doesn't get into questions of net recovery. Any recovery anywhere in those panoply of claims generates a right to payment on their part, regardless of the fact that, as my Lord Justice Arnold points out, it appears to have been offset or more than offset by losses elsewhere, but that's not the position that Candey have been adopting. I don't know what it is that they thought that they were going to generate their 29% of, if not the shares, but Mr. Wojakovski retained an interest in, a 50% interest in another of the Tonstate companies, THHL. He had other interests there, that his unfair prejudice petition, there were aspects of that which remained, notwithstanding the striking out of the main claim which held that his extractions were unlawful. He was also bringing claims saying that there had been payments out from the Tonstate Group to directors or de facto directors of the Tonstate Group, which ought to be restored. And so it may be that Mr. Wojakovski and Candey perceived that the ongoing pursuit of those claims, in circumstances where Mr. Wojakovski hadn't yet been made bankrupt, and so remained at liberty to pursue those claims, they may have thought that that would either generate a recovery on those claims themselves, or that it would give them sufficient leverage to try and do some wider global settlement which would resolve things. But
that's the only way it would work, because if money has come out of the company, money goes back into the company as a whole. It doesn't go to the petitioner.
Yes.
It would be reflective loss. Otherwise, it would. If you're claiming in an unfair prejudice claim that somebody's been extracting funds from the company, your remedy is usually to be bought out, and the fact that funds have been extracted from the company will reflect the value of your shares and the buyout.
Exactly. Yes. And so they clearly thought there was something still to play for here.
Yeah. So what you say is that there's a possibility that, irrespective of whether the unfair prejudice claim actually resolved at trial, there was the possibility of some kind of settlement which might involve funds being paid over to Mr. Wojakovski.
Yes. And there were, as well as the claims which Mr. Wojakovski had already made within the unfair prejudice petition, that there had been other sums wrongfully paid away to others, to Mrs. Robertson and Prakash Raithata.
Yeah.
There were those claims being articulated. There was also a very hotly contested dispute as to how much his father-in-law, Mr. Matias, needed to pay back into the company. The court may have seen from Mr. Justice Zacaroli's summary that there was a process by which, having struck out Mr. Wojakovski's defence as being legally misconceived, because it didn't matter whether or not there had been factual authority, that these extractions could never have been lawfully authorised, the necessary corollary of that position was that Mr Matias had to recognise that he had to pay back such extractions as had been made without proper tax having been paid and without lawful authority. And there was a process of account to which Mr Wojakovski was made subject as a result of an order. An equivalent account was the subject of consent by Mr Matias, who said, I will consent to an account to pay back what I owe. But Mr Wojakovski refused to accept the veracity of Mr Matias's account. So Mr Wojakovski, as at May 2020, may well have perceived that there was a possibility of continuing to apply real pressure to Mr Matias to pay back more money, and that was perhaps a justification for an increased percentage.
Well, even if he did, it wouldn't have gone to him, though. That's the point.
Not directly, my lady, no. But
I mean, the only way it seems to me that any money would have gone to him is if there was an overall settlement by which, in some way, shape or form, the remaining claims were bought off by a direct payment of some kind of payment in lieu of damages or something of that nature.
Well, that's true as in terms of a direct response to the claims, but the reality is that this was not a group which was any longer trading. The whole thing was an exercise of winding down the company's affairs, selling assets, and then there would then be a distribution at the end. And the companies, the companies, in fact, are all now in liquidation, and we're going through that process at the moment.
Right.
And so that it was always a question for Mr Wojakovski as to what cash he was going to end up with at the end of the day, in circumstances where the falling out with his father-in-law made any continued operation of the companies unthinkable. And it was just a question of who ended up with what at the end of the day.
All right, so that does actually put a commercial perspective on it. So you say, well, there were still some outstanding claims which might have had an overall impact on how much cash came back to Mr Wojakovski at the end of the day when all of the companies were wound up and everybody's interests were realised.
Exactly. But beyond that, as to why it was 4%, it seems to be just speculation, and Candey hadn't deigned to tell us what the rationale for that was.
Okay, is that construction dealt with?
That's construction dealt with, yes. So moving on to issue 2, which is the enforceability of the DBA. As my Lord Justice Arnold put to Mr Williams, the background, and we say it's the background of absolutely fundamental relevance to all of this, is the common law unenforceability of contingency fee agreements, save insofar as the combination of primary and secondary legislation has intervened to create an island of legality in that sea of illegality. And that was the metaphor used by this court in Zuberi, adopted by the judge. I understand that Mr Williams was poetic enough to have originally coined it in a much earlier case. And so that's the context for this. It's not a question of general freedom of contract. It's about a specific statutory carve-out from that which is otherwise unlawful.
And your fundamental point is you can't, if the position is that Parliament didn't even turn their minds to the question whether defendants could do that, how can you infer that there's a statutory carve-out for them?
Well, you've anticipated precisely my submission. It was Mr Williams' entirely proper concession to say that he couldn't point to anything at all to suggest that Parliament had turned their mind to this. And that was a proper concession because there is no such material, but in the circumstances that is fatal, because then one's left with the common law position in the absence of a statutory intention to depart from it. And so we head all of this off at the pass at the level of the primary legislation because no one has sat down and thought we need to modify the common law here. There's a need for access to justice. There are defendants here who aren't being able to fund their cases, and we need to provide a means of helping them with contingency fee deals. This hadn't occurred to anyone, and so therefore the common law unlawfulness stands in the absence of any intention to modify that position. So we do say that Mr Williams' concession this morning is fatal to his position in terms of statutory interpretation and parliamentary intention. As to that common law context from which Mr Williams would need to establish a carve-out, my Lord Justice Arnold gave judgment only a few weeks ago in another case involving a Candey fee arrangement. That was Farrer and Miller. It's in the bundle, Authorities Bundle 2, tab 38, and that's set out there from paragraphs 29 to 30 and onwards, the landscape of maintenance and champity Prior to 1990, solicitors could never conduct litigation pursuant to agreements which were to any extent contingent upon the outcome. The policy objections are addressed there at paragraph 33. There's the risk of a conflict of interest for solicitors who are motivated by their own financial self-interest to achieve a particular result, which may be in tension with their duties to the court. And these are sensitive and difficult policy considerations, which only with the utmost caution have led to the limited statutory intervention which has been made by Parliament in order to allow for CFAs and DBAs to the extent they can be employed. And it is simply wrong in principle for the court to do anything which expands the enforceability of these contingency fee agreements beyond what's already been legislated for, because it arises against a policy context and the risk of conflict of interest and problems in relation to that. So I can probably take this very quickly. Hansard, this is Authorities Bundle 2, tab 43. This is the debate in relation to the Coroners and Justice Bill. We had referred in our skeleton to what appears at column 408. Sorry? Oh, I'm so sorry. Is it tab 42?
Yeah, 43 is the regulations.
Oh. No, it's with the Hansard.
What page?
Yes, tab 42.
Page, yeah.
What do you want, the debate on the bill or on the regulations?
The debate on the bill, which should be hard copy, page 809.
That's 42.
Yes. I'm sorry, I've got the wrong reference. I'm so sorry.
Yes.
And so in the beginning of the second paragraph on that page, this is Lord Back, who was the Parliamentary Undersecretary within the Ministry of Justice. He explains, it may be helpful if I briefly explain how these agreements work. Damages-based agreements allow for the representative to claim a percentage of any damages awarded to the claimant. Now, obviously, Mr. Williams conceded that all of the discussion of this only ever contemplated the use of DBAs by claimant. So I'm not seeking to rely upon it to establish that proposition, because that's common ground. What's more important is at the bottom of that page, these amendments are necessary now to ensure consumer protection for claimants in employment tribunals. I emphasise that the amendments only seek to regulate damages-based agreements in respect of employment matters. These amendments do not extend beyond employment matters that may go to the employment tribunal. In particular, any potential extension of damages-based agreements to civil litigation would require further consideration by us at a later date. As the House knows, this is being looked at by Sir Rupert Jackson in his review of civil litigation costs. And so Mr. Williams was absolutely right to draw the distinction between the regulation of DBAs in an employment context and the anticipated or the potential legalisation of DBAs in a wider civil litigation context. But what's entirely clear from this parliamentary debate is that it was envisaged that that would be embraced within the Jackson reforms and the Jackson proposals. And that is at the extract from the Jackson report is at Authorities Bundle 2, tab 46. And then it's at page 872. Under the heading Other Funding Issues, paragraph 3.2, contingency fees. Now, Mr. Williams said, when he was dealing with the later section of Sir Rupert Jackson's report, that it was expressed in general terms which didn't exclude the possibility of contingency fees for the defence of incoming claims. But in that later section, Sir Rupert Jackson didn't need to express himself in those terms because he'd already defined contingency fee agreements in terms which excluded that possibility. And so hence at 3.2 he says that a contingency fee agreement may be described as one under which the client's lawyer is only paid if his or her client's claim is successful. And then the lawyer is paid out of the settlement sum or damages awarded, usually as a percentage of that amount. And there is just simply no way, as a matter of language, that that can be construed to contemplate the possibility of the use of DBAs for incoming claims. He's talking about claims being successful and percentages of damages. So when he makes his recommendations later, and when those are later implemented, there is just absolutely no basis to think that that was leaving open the possible use of these in relation to the defence of incoming claims. And so I don't think in those circumstances I need to go through all the legislation. We've mentioned it in our skeleton, LASPO, and the explanatory notes and explanatory memoranda, because Mr. Williams accepts that none of this helps. None of this gives any pointer to the idea that DBAs could be used for the defence of incoming claims. And obviously that doesn't mean that DBAs can't be used by defendants. And that this, on our interpretation of the DBA here, this was the use of a DBA by a defendant within an umbrella which provided effectively that Candey didn't get paid for their work other than through one of the sources of payment which I've identified. So it's not some umbrella prohibition upon defendants using DBAs. It's a question of the lack of any statutory intervention to allow for the possibility of a contingency fee to be paid based upon the successful or partially successful defence of an incoming claim. Only has in mind outgoing claims which generate some form of proceeds, cash or otherwise, which can be used to calculate the solicitor's entitlement, and from that pot of newly acquired cash or assets can the solicitor be paid. In short, it's about winnings. And so what Lord McNally said about the scope of the Act in 2013, we say was absolutely right. It's not an admissible matter of statutory interpretation because it postdates the enactment, but he was right about it, and that's clear both from the parliamentary debate and also from the letter that was placed in the House of Lords Library, his letter to Lord Beecham, authorities, volume 2, tab 45. And
I don't think we've got, have we, any debate on the bill itself? Is that because there is nothing which either party thinks is relevant either way?
On the which bill, my lord?
The LASPO.
No, I don't think so. No.
Sorry, you mean you agree that we haven't got it? Or
I agree. You haven't got it. No, the only relevant extracts. No, that's right. But basically, there's the extract from Hansard at tab 44, which is debating the regulations, and then what Lord McNally says was reconfirmed in the letter at tab 45, and then the earlier Hansard Act extracts are from 2009 and 2010 in relation to the predecessor legislation. And so, but it appears to be common ground. This was merely Mr. Williams' position that basically it didn't occur to anyone.
Okay.
But on this point, in terms of the interpretation of the legislation, Mr. Williams was quite wrong to say at this level that it hadn't occurred to anyone, because it plainly had occurred to Lord McNally as to whether or not DBA should be extended to defendants, and he positively said, no, it doesn't apply to defendants. So the most that can be said by Mr. Williams is that there was an oversight in terms of the enactment of the primary legislation. There was no such oversight when it came to the regulations, because the assumption upon which the regulations were made is that you couldn't do this. You couldn't have the use of a DBA to cater for incoming claims. And Lord McNally was perfectly clear about that. And he thought, we say rightly, Mr Williams says wrongly, that was because it wasn't permitted by the primary legislation. But whether or not he was mistaken about that when it comes to interpretation of the regulations doesn't matter. It's what the assumption and the intention was when making the regulations. And then we see the regulations themselves at tab 9. I don't think I need to repeat my submissions because they were set out by the judge, set out in our skeleton. Mr Williams fairly summarised what we seek to derive both from the definition of payment and the concept of funds being ultimately recovered, which appears in Regulation 4.3. And this isn't some circuitous way of defining the scope of the usage of these regulations. It's just a fundamental premise upon which they have been enacted. And so it just goes without saying, they're described as damages-based agreements. The explanatory memoranda and the explanatory notes, as my learned friend rightly concedes, contemplate their use only by claimants. And so in that context, the way in which they have been drawn up, so that the type of payment contemplated is only a payment which has been derived from a sum which has been recovered, we say that that's entirely is what one would expect to see. And the fact that the Act goes further and refers to obtains a specified benefit, the fact is that the regulations haven't themselves picked up that language. It's only concerned with sums recovered. And the way in which the transfer of value occurs as between the solicitor and client can be, of course we accept, that can be by way of a transfer of money's worth. But that's a neutral consideration. The question is whether the regulations allow for the possibility of a calculation of a solicitor's entitlement by reference to the value of property which the client had in the first place. And there is not a hint within the regulations of that being permissible. And unless that's been prescribed by the regulations, then it's therefore unlawful and unenforceable under the scheme of the legislation, which obviously contemplates not that the primary act in one fell swoop will legalise all forms of DBAs. It contemplates that it, in principle, gives the regulation-making power for the Lord Chancellor to prescribe how these should work, and that those regulations can only be issued after a process of consultation with the bench, the bar, the law society, and other interested bodies to ensure that the appropriate balance is being struck between consumer protection, access to justice, potential solicitors' conflicts of interest. But we place real emphasis on the practical difficulties which we refer to in our skeleton, which were the topic of some of the exchanges earlier today, as to how on earth this would work in relation to the defence of incoming claims. One sees how it's intended to work in relation to personal injury claims, employment claims, and other civil litigation, because one simply applies a percentage value to the property which has been obtained, or the damages, rather, that have been obtained, or damages or equivalent. And so that one has the sum that percentage can be applied to. It's just simply unworkable on the regulations as they are to cater for the evaluation of the benefit of the defence of an incoming claim. It just simply doesn't work. And that would have needed to be the subject of real consultation with these interested groups as to how this was going to work. In terms of the volume litigation that Sir Rupert Jackson had in mind, such as employment claims and personal injury claims, obviously he heard from all sorts of interested parties as to how this should operate. And one sees from the report there was vehement opposition in some quarters to the implementation of DBAs. If it were the case that there was the possibility of defendants entering DBAs, all of this would have needed to be debated. And you only need to posit the example of someone who is cash poor but asset rich and perhaps very unsophisticated to realise why all of this would need to be very carefully considered. The little old lady who is facing some neighbour dispute which is significantly devaluing the value of a house, but she doesn't have the cash available to fund her lawyers, would it be said that the solicitors who come to her aid are then entitled to a percentage of the value of the house that they have preserved by their defence of an incoming neighbour dispute? And all of these consumer protection considerations would have needed to have been very carefully debated, and there's none of that, and Mr Williams accepts that, because they simply didn't have this type of agreement in mind. And as to the ultra vires point, for the reasons that we give in our skeleton, we say there's absolutely nothing in that whatsoever, because the most that Mr Williams says is that the regulations were ultra vires in terms of they did something which was beyond their power to do. But the problem with that is that they've purported to do it, and this court can't read down the regulations. And if there isn't a set of regulations which are effective and intra vires to legalise a particular type of agreement, then it takes Candey nowhere, because they need to establish that their agreement is compliant both with the Act and with regulations made thereunder. And of course these regulations have been made thereunder. It's just a question of Mr Williams, his last ditch submission, says that they have been made in excess of the powers. And so it just doesn't go anywhere. But it's also completely wrong because the scheme of the Act and the secondary legislation is that the Lord Chancellor was given regulation-making powers, including to prescribe terms and conditions, including to distinguish between types of agreement which could be entered into and types of agreement which couldn't. And so it always contemplated that a power was made available to the Lord Chancellor to make these regulations, whether or not the full breadth of that power was taken up so as to allow for the possibility of defendant DBAs, was entirely a matter for the Lord Chancellor. So the very most that can be said, and this is the way Mr Justice Zacaroli analysed it, the very most that can be said is that the Act is permissive and neutral and doesn't preclude the possibility of DBAs for incoming claims, but the regulations have only allowed for the possibility of solicitor payments which are derived from sums recovered. And we say that's an entirely coherent, sensible scheme, and Mr Justice Zacaroli on this aspect was entirely right, but he could have gone further, because with the time limits and the limited research that we had done at that stage into the legislative history, we weren't seeking to persuade him that the Act precluded this, whereas in fact in this court...
It's not so much that he could have gone further, but that you could have gone further.
Well, yes. Together, my lord, we could have taken the analysis further, but it wasn't necessary to do so because the regulation seemed so clear. But it seemed to us to be the right thing to do as a matter of principle when we were before this court, to actually test the assumption upon which it was proceeding below. Not least because I know that there are moves afoot. There is the Civil Justice Council who have been looking into the question of the scope of DBAs, and it may be of considerable benefit for the clarification from this court that in fact the Act, as currently drafted, just doesn't allow them, and there would need to be some further statutory amendment and perhaps some consideration of the wisdom of expanding them in that way before that step was taken. So I rattled through that rather quickly, but those are my submissions on the second part.
Right, that's completed what you've got to say about that. We'll hear from Mr Williams in reply on the DBA points.
Yes, I'm just going to be. I'm going to rattle as well, if I may. Just a few points, really, mostly on the contractual construction. My learned friend takes what he accepted was a new nuance on the word proceeds. And I accept, as I have with others, that that's a term which might in isolation, in other circumstances, carry with it the implication of new funds. But I come back here to a point I've made before in our submission. That's falsified in this context by the shares claim, where there could be no funds. And against that background, it's just to be interpreted as a collective term, rational in its context, which pulls together into a single label the two different things it covers, namely recovery of new money and derivation of benefits. As to my learned friend's casino analogy, it's vivid, but it's obviously misplaced because it's not about a roulette wheel. This is about a man who is in a very difficult position, who retains a solicitor to reduce or extinguish his liability in the shares claim, which they did. So it's not. It was an enjoyable analogy, but not in my submission a sound one. My learned friend echoes the judge in saying, well, and there's another objection. It's not just about no mechanism to value the shares. There's also no mechanism by which the netting off of the tax liabilities, if any, can be determined. And not only is there no mechanism, but there's also no provision for how the agreement might operate in what, in that context, might be many months or years of delay. That, again, is a criticism of the structure of the agreement, which obviously I accept it's not there. But what I do say is precisely the same trouble or problem arises, even in the most simple scenario where, let's suppose, for example, in the main action, Mr Wojakovski succeeds and gets a large monetary award in his counterclaim. That monetary award is also subject to the netting off of a tax liability. But nobody has suggested that in that context, the need to, notwithstanding the practical difficulties that gives rise to, that somehow invalidates the transaction. So in my respectful submission, it isn't an answer. Yes, it is another demonstration that in certain respects this agreement has not been completely thought through, but it doesn't illustrate more than that. My learned friend then made a point about non-commerciality and the 10 million that would have resulted on the assumption that the shares had their full. I'm so sorry that if the case had been dismissed, so you're escalating up from the 2 million. Well, I accepted this morning that the 2 million is doubtless an overstatement for the reasons that were addressed in circumstances where Candey were only able to conduct a very crude valuation based on balance sheets. But even supposing the figure to be right, that would mean the result of the litigation, conducting the same exercise as my learned friend. If it's a 10 million payment to Candey, then it's then Mr Wojakovski has resisted a claim for shares which have been left in his hand at a value of 35 million. That's simply a function of my learned friend's own figures.
No. It's not so much about the pure figure. It's that he's exposed to a liability of the order of £10 million, which on your thesis, he has to pay out of his own resources, when his own resources were what led him to Candey's lack of resources, led him to Candey's door in the first place.
But the answer,
if he had the resources, he could have carried on funding Mishcon Direct.
But the answer to that is on the this scenario only arises if at the end of the litigation he is emerged holding an asset, 29% of which is worth £10 million. That means that's 29%. That means he's got the other 71%. The reason he's impecunious is during the course of the litigation he's unable to deal with the shares, so they have no tangible value to him. Inter alia, he gives an undertaking to resist to avoid a freezing order.
These aren't tradable on the stock exchange. This is a shareholding in a private company. Notoriously difficult to value. It's not as if they're shares in Marks and Spencer's.
But then, with respect, it's ultimately a self-policing point because Candey are only ever entitled to 29%. So if the value transpires to be nothing or negligible at the end of the case, then his liability to Candey is also going to be 29% of nothing or negligible. If, on the other hand, the shares do transpire to be valuable for whatever reason, then his liability to Candey will be larger. But ex hypothesi, it's only ever going to be 29% of the value which is left in his hands by virtue of Candey's endeavours.
I think with respect, you're failing to grapple with the fundamental point of principle that my lord is putting to you, which doesn't actually turn on how much the shares are worth or not worth. The point is this: a man looks at his current assets and says, I can't afford to pay my lawyers out of those assets, whatever they're worth. At the end of the litigation, he ends up with the same assets. Why should he agree to pay the lawyers in the future out of those same assets when he takes the view at the time, when he's about to engage them, that he can't afford to pay them then and there? It's a fundamentally stupid bargain.
Well, because in the real world, if it's a fundamentally stupid bargain, he is not going to retain the solicitors to defend a worthless asset, and the solicitors are not going to agree to, on contingent terms, do years of work defending a worthless asset. I mean, to some extent, there is a sort of basic commerciality at the start of these agreements. These agreements are only going to be entered into by solicitors or clients if it's felt that at the end of a process of defending an asset, there is going to be something of tangible value. And I do return to the point that whatever the figures one may inject into it, and they may be for the purposes of testing it to absurdity, be tiny or enormous, or they may be realistic ones. But whatever figures you inject, because all the solicitor ever gets is a percentage, which as a matter of law can never be more than 50%, and in this particular agreement is well under 50%, the solicitors can never take more out of the asset than the asset is worth. In fact, they can never take more out of the asset than half its worth, because that is the effect of the DBA cap. So it is ultimately a self-policing point. If irrational actors enter into an agreement whereby the solicitors will do vast amounts of work to defend an asset, and at the end of the litigation, the product of the defence is to yield an asset which is worthless or nearly worthless, the solicitors get 29% of nothing. So that's what I mean by describing it as a self-policing point. And then lastly, on the contract, my learned friend described it as appallingly drafted. And I recognise that I was myself somewhat unflattering about aspects of it in my own submissions. And of course, it's open to criticism. But in fairness, I should stress that from the perspective of Candey, this was a well-intentioned attempt on their part to help a client whom other lawyers weren't willing to help, under an agreement deliberately kept to one page, rather than the dozens of pages of dense legalese, which are all too frequently encountered. And if that well-intentioned attempt by Candey has failed, then of course they bear the consequences. But I should emphasise, in fairness to them, that this is not something which has resulted from insouciance or flippancy on their part, or any neglect of regulatory responsibilities, which they as a practice take very seriously. It was an attempt to keep things simple, and if that is miscarried, then so be it. But as I say, I recognise that I was myself slightly harsh in some of my language this morning, and that was perhaps unfair to my clients. And I feel that I should mitigate what I said with those sort of counter-weighted words.
All right, well, we understand that.
Thank you. So far as enforceability is concerned, I've really only got a couple of observations. I don't have any, so far as travail préparatoire are concerned, obviously I accept that the explanatory notes, the explanatory memoranda and Lord Justice Jackson's reports are all admissible, and they all proceed on the claimant exclusive premise I've conceded. I don't become so pompous as to actively object to Hansard being looked at on pepper and heart grounds. No difficulty with it being looked at de bene esse, but I have to say that for my part, I wouldn't seek to persuade the court this is actually a case where the pepper and heart requirements to take Hansard into account are actually met. Neither of us is suggesting that the Act itself contains words which are so obscure one needs to resort to parliamentary authorities. We simply present different arguments to you as to what the plain meaning of the words is. So far as the ultra vires point is concerned, obviously on the second aspect of his point, my learned friend directly joins with me as to whether my argument is good or bad, and I'm not going to repeat that argument. The court has it. But he preceded that with a point where it doesn't go anywhere, because even if it's ultra vires, you're still left with regulations you have to comply with. But in my submission, that can't be correct. Unenforceability under the Act, under subsection 1 and 2, under subsection 1 of the Act, a DBA is unenforceable if you don't comply with the regulations prescribed by Regulation 4. That unenforceability can only relate to non-compliance with regulations which were made intra vires. So I do suggest that my learned friend's attempt to simply say the point is utterly irrelevant is wrong, but I do accept that then simply takes one as to whether it stands or falls on the merits, and you have the arguments on that.
But what is the position if we say that the regulations are ultra vires? The regulations are then struck down, and there are no regulations.
Yes.
So can you recover simply on the terms of the Act
Then only
in the absence of any regulations?
Well, yes, but of course it doesn't necessarily mean the entirety of the regulations is struck down. Well, the proposition is simply that insofar as if the regulations, well, you have what my criticism is, that whereas regulations are empowered to impose essentially a cap on the amount of the payment. The power to award a cap doesn't allow the regulator also to define payment in such a way that reduces the scope of that which the Act authorises. So
I'm still puzzled as to how this works. So your starting point is that at common law, these agreements are unenforceable. Statute then intervenes and says, if you comply with the regulations, they are enforceable. Suppose the regulations are then ultra vires. How then are they enforceable?
Well, there isn't. Let's have a look. I don't actually, from memory, believe there is an obligation to. No, there's no obligation. There's simply a facility for regulations to be made. Yes.
The statute refers specifically to you having to comply with regulations.
Well, if you recall, there are a number of rule-making powers. I showed you 4C, which you must comply with regulations as to terms and conditions. And I took you to Regulation 3, which stipulates these are the specified terms and conditions. There's no suggestion either that those are ultra vires or that Candey has not complied with those terms and conditions. My learned friend did argue that below. He failed on it and he didn't renew that by his respondent's notice. My argument was that the regulation which is here in contention is the point about the cap on the payment. And that regulation, that's that subsection, I'm so sorry, it's subsection 4B is prefaced, if regulations so provide. So if the regulations which so provide are, because you've accepted my argument on the merits, ultra vires, then there are no regulations which so provide.
But C and D certainly contemplate that there will be requirements in regulations that have to be complied with.
Yes. Well, so far as C is concerned, if you'll recall, I took you to Regulation 3, which is sort of identifies itself as these are the regulations under 4C. Would it help me to turn those back up?
Yeah.
That's tab 8, I think. No, not 8.
9.
9. It's page 87.
Regulation 3, isn't it?
Regulation 3, where you see the superscript, as it were, the rubric, the requirements prescribed for the purposes of 58AA 4CR, and there are 3 of them. So those, no one suggests that those are ultra vires or that Candey hasn't complied with them. And so far as my Lord Justice Mail's reference to subsection 4D, that's a subsection under which, again, there's a facility, it's just a facility to prescribe pre-contractual information. And no pre-contractual information for civil DBAs has been prescribed. There has been a prescription for employment DBAs, but not for civil DBAs.
Can you tell us, since you've said that you're not saying the regulations are ultra vires in their entirety, can you identify which words in the regulations are ultra vires, and whether that means we simply, if we agree with you, strike out those words or somehow put other words, and if so, what words, in their place?
Well, as you're aware, it's a definition of payment, and
Right.
it's really the interpretation of the word recovered. And as you'll recall, my first submission was that purposefully that could essentially be giving a strained construction, so as to essentially to be read recovered or preserved.
Yes. Well, that's your submission on interpretation.
Yes, yes, but I suppose.
But on ultra vires, we strike out the word recovered and say that has to be read as recovered or preserved?
Yes, it essentially would be the mirror of that point.
Okay, thank you.
Yes, that's my reply.
Anything else, Richard? Okay. All right. Well, we'll rise and see where we are. Well, we're very grateful to you both for your submissions. We don't need to hear argument on the Lien point. The consequence of that, as you will appreciate, is that the appeal will be dismissed. We will put our reasons in writing and circulate judgments to you in the usual way. You will understand that the judgments are subject to an embargo until they are handed down, so that there are strict conditions on who may see them and the use to which they may be put. That must be explained to anybody to whom the judgments are circulated. I say all that because I know that you will know it, but there have been a number of cases recently where problems have arisen, and this must not be another one of them.
Not just on this side of the Atlantic.
Well, indeed. If there are corrections of a typographical or factual nature which need to be made, then please submit those and agree an order. you will also appreciate, but I'll say it anyway, it's not an opportunity to re-argue points. If you can't agree an order, then we will have short written submissions on whatever remains in dispute, and we will hand down the judgment remotely and deal with any consequential issues without a hearing. I think that's everything I need to say.
Well, could I just request permission in anticipation to be able to share the judgment with Mr Wojakovski's trustees in bankruptcy? I think there would already be scope to share it with the liquidators of the companies because they represent the companies, but Mr Wojakovski's trustees in bankruptcy would have a...
Will they need to have any input on agreeing the terms of an order?
I wouldn't have thought so in terms of agreeing the terms of an order, but I suppose we could wait, yes.
Well, I think wait and see.
Yes.
The fewer people who get it, the better.
Yes.
Only if they need to see it for the purpose of either agreeing terms of an order or checking any factual points which you are unable to check for yourselves.
Yes.
You are, of course, able to tell them the result now because that's been announced in open court.
My lord, yes.
Yes. Yes. All right, well, thank you both again and to all the teams behind you. As I said, we will circulate our judgments.
Thank you.
All right.